Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. So I haven't covered anything lately as far as the Idaho 4 case is concerned, but I did want to go over, we just got documents and there's an upcoming hearing for Bryan Kohberger as far as his alibi is concerned. Now, apparently he doesn't really have much of an alibi, and remember how he didn't put in a plea, so he pretty much didn't want to even put in an alibi. So it seems like he's wanting to remain silent for the most part. So let's go through and tailor his attorney's response to the state when they were seeking Bryan Kohberger's alibi. So this was electronically filed. Try to get up here. I'm trying to make it as big for you guys as well. On the 2nd of August, so we just had a filing of this. Obviously, there's A.N.C. Taylor, public defender, and also his other attorney there, Eliza Massoff. Attorneys at law, and he's got a third attorney, J.W. Logston. And again, this was filed on August 2nd in the District Court of the 2nd Judicial District of the State of Idaho in and for the County of Latah. State of Idaho, plaintiff versus Bryan C. Kohberger, defendant. Of course, we get the case number. Objection to the state's motion to compel motive of defense of alibi, or alternatively to bar certain evidence. Comes now Bryan C. Kohberger by and through his attorney of record, A.N.C. Taylor, public defender, and hereby and objects to the state's motion to compel motive of defense of alibi, or alternatively to bar certain evidence. Idaho Code 19-519 and ICR 12.1 require an alibi disclosure of a specific location with a specific location and witnesses to so testify. By statutory definition, Mr. Kohberger may remain silent yet testify that he was not at 1122 King Road on November 13th, 2022. However, in an abundance of caution and recognizing the court has authority to exclude witnesses, Mr. Kohberger has indicated he anticipates corroborating witnesses. When determining whether to exclude evidence due to late disclosure or non-disclosure, the trial court must weigh the prejudice to the state against the defendant's right to a fair trial. Albert 138 Idaho at 287.62, P3D at 211. It is error for a trial court to exclude a witness based solely on late disclosure without analyzing whether the state would suffer prejudice from the late disclosure. State versus Lampshire, 130 Idaho 630, 634, 945, P2D 15, 1997. In addition to weighing competing interests at stake, the trial court should consider whether less severe remedies would be sufficient for the untimely disclosure or non-disclosure, such as a short continuance, a mistrial, or sanctions against defense counsel before excluding a defense witness. State versus Thomas, 133 Idaho 800, 803, 992, P2D 795, 798, Court 8 App 1, 1999. Lots of numbers. The trial court has an obligation to, quote, fashion a sanction which will impress counsel with the importance of responding to discovery requests and yet will not prejudice the defense of the case, unquote. State versus Stradley, 127 Idaho, 203, 211, 899, P2D, 416, 424, 1995. However, when the defendant's discovery violation was willful and designed to facilitate the presentation of fabricated testimony or to impede the state's ability to conduct effective cross-examination or to present Rebuttal evidence exclusion may be a proper remedy, notwithstanding the availability of other sanctions that would prevent prejudice to the state. Tailored 484 U.S. at 414-15, 108 South Court, 646 Albert, 138 Idaho at 287, 62 P3D at 211 State versus Juarez, 169 Idaho, 274, 277 494 P3D, 822 825 Court App 2021. Registered denied September 27, 2021. Mr. Kohberger has long had a habit of going for drives alone. Often he would go for drives at night. He did so late on November 12th and November 13th, 2022. Mr. Kohberger is not claiming to be at a specific location at a specific time. At this time, there is not a specific witness to say precisely where Mr. Kohberger was at each moment of the hours between late night November 12th, 2022 and early morning November 13th of 2022. He was out driving during the late night and early morning hours of November 12th through the 13th of 2022. Convenient, isn't it? It's kind of a good and bad alibi at the same time. It's kind of hard to prove that you were out driving alone, although they may find areas that may have caught him on camera, and what have you. I guess we're going to see where the defense counsel is coming with that one. Counsel for Mr. Kohberger is aware that case law broadens the definition of alibi with the statutory requirement of a specific location to more broadly include disclosure of information that tends to state the person claiming alibi was at a place other than the location of an offense. Mr. Kohberger has complied to the extent possible at this time. Corroboration of Bryan Kohberger not being at 1122 King may be brought out through cross-examination of the state's witnesses. At this time, Mr. Kohberger cannot be more specific about the possible witnesses and exactly what they will say. The defense has been hampered by the state's own choices. The state chose a secret grand jury rather than the planned preliminary hearing. Had the state moved forward with the preliminary hearing, the defense would have had the opportunity to develop testimony through cross-examination and witness presentation. That's convenient, isn't it? Oh, if we would have had this preliminary hearing instead of y'all just going, oh, we're going to have this secret grand jury, you might have learned more. Instead, the defense has only received on July 27th, 2023, a copy of the testimony the state chose to elicit. Review of such is underway. The defense had to obtain investigative materials from the state's investigative counterparts, the FBI, through an order compelling the state to provide such materials. The state made draft disclosures just 2 weeks ago. The sufficiency of these disclosures is currently being analyzed. Doesn't seem like Ms. Taylor's too happy with the state on how they're doing things at all. Corroboration of Bryan Kohberger not being at 1122 King may be brought out through expert witness presentation. That analysis is underway. The defense has been diligently working to analyze relevant discovery materials and conduct its own investigation. Notably, the defense had to obtain a court order to receive relevant discovery materials. That delay hampers the defense investigation. Again, it seems like they're saying, it's all the state's fault that's taking this long. They didn't tell us. There was a grand jury. They're taking forever to get us stuff, so this is all y'all's fault. The right to offer the testimony of witnesses and to compel their attendance if necessary is, plain terms, the right to present a defense, the right to present defense's version of the facts, as well as prosecution to the jury so it may decide where the truth lies. Just as an accused has the right to confront the prosecution's witnesses for the purposes of challenging their testimony, he has the right to present his own witnesses to establish a defense. This right is a fundamental element of due process of law. So that's the law there, and of course they're stating all the relevant cases, the defense acknowledges a vast amount of discovery has been provided. Discovery is received on a nearly weekly basis. The defense reviews and acts on the discovery as quickly as possible, including making appropriate supplemental requests for discovery. The state's motion is an attempt to force the defense to open its work product files and let the state peek inside. The defense has stated all that can firmly be stated at this time. This is not trial by ambush from the defense. This is a defense requesting information as quickly as possible, yet in some instances face a delay of requesting a court order to obtain information. The state continually uses those opportunities to attempt force a waiver of speedy trial. That is a decision left to Mr. Kohberger and Mr. Kohberger alone. Mr. Kohberger was out driving alone. Corroborating evidence may come from cross-examination of state's witnesses. Corroborating evidence may come from presentation of defense experts. Mr. Kohberger is aware of and will comply with his continuing duty to disclose information. The court may exempt Mr. Kohberger from further inquiry. Mr. Kohberger requests such an exception at this time. Continued inquiry at this juncture delves into his case investigation as well as protected work product. In support of an exemption, Mr. Kohberger is prepared to provide further detail in ex parte hearing with the court. Right, and it's signed by, of course, his public defender, Miss Ann Taylor. All right, and this is the District Court of the 2nd Judicial District of the State of Idaho in and for the County of Lata. Now this one here is the notice of the hearing. The hearing is going to be on August 18th at 10:30 a.m. Notice is hereby given that Bryan C. Kohberger, by and through his attorney, Ann C. Taylor, public defender, will call on for hearing the below motions in the above entitled matter on 8/18/2023 at 10:30 a.m. or soon thereafter, as counsel may be heard in front of the Honorable Judge John Judge. I still love his name so much. Won't get tired of saying, Mr. Judge. Defendant's third motion to compel, filed June 22nd, 2023. Defendant's second motion to stay proceedings, filed on July 25th, 2023. Defendant's motion to dismiss indictment on grounds of error in grand jury. Yeah, they really are trying hard on that one. Instructions or the alternative remand for preliminary hearing, filed July 25th, 2023. So they're having that hearing because they're trying to get a lot thrown out. So Ann Taylor, I from what I can tell, everything that she's doing, and of course she's already well known, but she's definitely doing an amazing job for Bryan Kohberger. Whether we like him or not, he has a great attorney. But I'm pretty sure we're not going to get any of this stuff thrown out. She definitely seems really hurt and not pleased by the fact that the state went and did that grand jury and then instead go, oh, we got this grand jury indictment, so we don't need to do the preliminary hearing. So she seems pretty teed off about that. And of course, she doesn't want to have to provide much more of an alibi for her client. And I don't know, I think it's pretty like low. I mean, I don't find his alibi too exciting. He was driving around by himself alone at night. Sure, that's possible, and if he killed these 4 beautiful people here, he was driving around by himself at night. So that would be still a truth. So as far as that's concerned, I think he's probably telling the truth on that. He was driving around at night by himself. The question is, did he stop at 1122 King Road? He's saying he didn't. But evidence and time will tell.
Based on one surviving witness's accounts, investigators believe the deaths happened between 4 and 4:25 that morning. Kohberger's lawyers say their client had a habit of taking long drives alone, and that is what he was doing late November 12th and into the early hours of November 13th. Joining me now to talk about this latest development is criminologist Dr. Debbie Goodman. Dr. Goodman, thank you so much for being here this afternoon. It sounds as though Kohberger's defense team has a plan that they plan to go with. Do you think it will work?
Well, good afternoon, Nick. Always a pleasure to join you. I think this plan of a defense is aligned with Swiss cheese for me, Nick, as a criminologist. Why? Because there are way too many holes and simply not enough substance and solid information. So we can remind the viewers when we talk about an alibi is something that is to dispute that the whereabouts of the defendant at the time of the crime. So he's alleged to have been at the home.
I like how she calls it Swiss cheese. It's like there's just so many holes in this supposed alibi. I think it's flimsy. I really do. I think it's flimsy.
But to simply say that he's on this long drive, there's no verification. An alibi is designed to either it's a person who can say where this individual was during this time period of November 12th to the 13th. It could be an item, by the way. It could be something such as a receipt where one was at a particular place where we've got a time and a date stamp. It could be surveillance of, closed caption type of TV. But to simply say that one is driving and there's no way to substantiate that, I feel it's very weak.
Yeah, so he's gonna need to have, like, again, that's what I was saying before. He needs to have surveillance footage of himself, his vehicle that's clear, like a receipt, like she said, video of him inside somewhere. I mean, if you're simply just driving around and there's no person, no receipts. Bottom line, no paper trail. It's just not going to work out too good.
And Dr. Goldman, even if you were to produce surveillance video or a receipt of some kind, would they still have the burden of explaining away what prosecutors say they have as evidence of cell phone pings of his vehicle being near the home and casing the place before the murders occurred?
Right. That's a great point to bring up. So now we can pivot to what the prosecution will be presenting in October. And we already know it's going to be very solid.
See, this is good. See, I think the state's got a very good tracking on Kohberger's phone. This is a good timeline right here. You have 2:42 a.m. Kohberger leaves apartment in Pullman, Washington. Then at 2:47 to 4:48, his signal is lost. So that doesn't help him at all because they don't have any GPS showing that he was either in that area or not. And then you've got Kohberger traveling back to Pullman at 4:50 to 5:26 a.m. And then Kohberger traveling to Moscow at 9 a.m. And then Kohberger returns to the murder scene 9:12 to 9:21 a.m. because he wanted to make sure he see what was going on. It's like, the criminals want to return to the place of the crime and see, hey, the cops here. Yeah, it's like makes me think of like an arsonist or someone coming out there and just going, let me admire my handiwork. And then Kohberger arrives back at his apartment in Pullman around 9:32 a.m.
Nick, very substantial to include his DNA, meaning the suspect, on this knife sheath that is directly at the crime scene. And to your point about the cell phone data and the pings, that's huge for the prosecution, showing that this individual is right there in close proximity to the crime scene of the home. We also have more. We have his car on footage. And what I think is also going to be really insurmountable for this defense is that this individual reached out to one or more of our victims on social media. We will also come to find out that he has pictures on his phone of one or more of our victims. So for me, we're really talking about just a lot of important, substantial data that the prosecution has and will introduce as evidence. And the defense, I feel, is just trying to grasp at straws and come up with something. But if that's all they have, it is terribly weak.
And Dr. Goldman, help though for our audience at home to understand that it's not a crime for a young man to go on a drive and possibly be near a home where something eventually occurred, or to have pictures of attractive girls on his phone or whatever. But what you're saying is it's the culmination of those things that actually that circumstantial evidence in whole could help to build a case.
Absolutely, Nick. And we know that many high profile cases that we have discussed on the platform have been deeply rooted in the circumstantial. That's absolutely true. But remember, on this particular case, we have both circumstantial as well as tangible. I'm starting with the DNA. You know, we have to look at that first and foremost, that who among us, right, the million, billion, trillion, but on this case, we're in the numerical of octillion, that nobody else's DNA was found at this crime scene other than this suspect. So it will be very interesting as it plays out, but I just think we've got overwhelming evidence from the prosecution versus potentially what this defense is coming up with as a long drive to nowhere with nobody seeing him and nobody substantiating this.
Exactly. You're, again, like I've said, same thing. It's like they're grasping at straws, they're throwing stuff at the wall. And again, I do think Ann Taylor seems like an excellent attorney. And so that's not going to be something that he's going to be able to try to appeal on for sure. But driving around, because that's what he just does, it's not strong at all. And there's all this other evidence. You know, you got these phone pings, you've got him turning off his phone, you've got the DNA on the sheath, which of course some people are less than thrilled by, from what I've heard. You know, these photos again that he was following these people. There's just so much, in my opinion, that just makes him look guilty. But I think he's good for this, and he's definitely seems like the type from the actions that we've seen. But like anyone else, he deserves a fair trial, and he's going to definitely get that. I think as much as he's getting flack for. But let me know what you guys think of this new quote unquote alibi, which I don't think is a real alibi. But let me know what you think, and do you think Bryan did it? Do you think he's the one who went into 1122 King Road and he killed these 4 college kids? Or do you think there's more to it? Let me know. And with that said and done, that's all I've got for this one. I hope you guys have a great rest of the day. And most of all, stay safe.